Good morning, Commissioners. I appear with Ms Molyneux as Counsel Assisting.
Please you, Commissioners Fordham. I appear with Ms Wright for the Commonwealth.
Commissioner Douglas is speaking, but we can't hear him.
Are there any appearances from any of the states?
No, Commissioner.
Thanks. Yes, Ms Longbottom.
Commissioners, this directions hearing will be in two parts. The first part of the directions hearing will be live streamed on the Royal Commission's website, and it is a public hearing. The second part of the directions hearing will be a closed hearing. We had not intended that there would be a closed part of the directions hearing today, but at approximately 6:56 p.m. yesterday, the solicitors assisting the Commission received a letter from the Australian Government Solicitor. That letter contained critical information which is relevant to hearing block 9. The information that was provided in that letter is important to the evidence to be heard at hearing block 9, but it is also sensitive. And in that circumstance, we think that the matters relevant to that letter need to be dealt with in a short closed session following the public hearing. We would have liked to have been in a position to inform those watching the Commission's live feed of the closed session sooner, but because of the late receipt of the letter, we haven't been able to do that until this morning. Before turning to the matters, the subject of the directions hearing, can I just attend to a housekeeping matter in relation to various bundles of correspondence and letters that are relevant to the issues that we will discuss? We don't propose to tender any bundles of material, but we do ask that 2 bundles of correspondence and 2 letters be marked for identification. If I can go through each of those in turn. The first is a bundle of correspondence with the document ID reference STU.0000002.0002.9773. That's a bundle of correspondence between the Commission and legal representatives for the Commonwealth. We ask that it be marked as MFI 2 because the MFI 1 allocation or marking was allocated in an earlier hearing block.
That bundle of documents will be marked MFI 2.
Thank you, Commissioner Douglas. The second is a supplementary bundle of correspondence between the Commission and the legal representatives for the Commonwealth. It has the document ID reference STU.0000.0003.0052. We ask that that be marked MFI 3.
That will be done. That bundle will become MFI 3.
Thank you, Commissioner. There are also 2 letters that were received from AGS last night. The first of those letters has in the subject line a reference to hearing block 9. We ask that that letter be marked MFI 4.
That'll be marked MFI 4.
And the second of those letters we ask be marked MFI 5.
And does that have the HB9 reference too?
It doesn't.
Doesn't, okay. It'll be marked MFI 5. Is it dated yesterday as well?
Yes, they're both dated the 27th of April, Commissioner Douglas. The distinguishing feature between them that it's appropriate for me to raise in an open session is that the first of the letters has in the subject line hearing block 9, but the other doesn't.
Righto. Thank you.
Commissioners, the Royal Commission has been redoubling its efforts to obtain the evidence necessary to fulfil its terms of reference. The last hearing block took place in Wagga in December of 2022. Since that time, the Royal Commission has issued over 150 notices. Those notices have been issued to the Commonwealth and state government organisations, including Defence, DVA, some individuals and health agencies in each of the states and territories. The matters that are the subject of those notices are many and varied, but include leadership and accountability, unacceptable behaviour, health services provided by Defence or to veterans by the states and territories, transition from military life, deployments, rehabilitation processes and programs following injury to Defence members, return of service obligations, and homelessness. In addition to the work being undertaken by the Royal Commission in terms of issuing notices, I note that the Commonwealth, states and territories have also been consulted on a number of draft notices. Alongside that work, Royal Commission staff have undertaken site visits to Defence bases in New South Wales and Western Australia. The purpose of those site visits is to meet and talk with members in their working environments, to facilitate the Commission's understanding of issues facing members of the Defence Force, as well as to assist with the preparation of upcoming hearing blocks. You Commissioners have participated in over 175 private sessions since December of last year. Those private sessions, while confidential, are invaluable to the work of the Royal Commission because they provide you with an opportunity to hear first-hand accounts of veterans and their families with lived experience of suicide and suicidal behaviour. And in addition to all of that work, those assisting the Commission have participated in roundtables and briefings from various stakeholders. Commissioners, those efforts are crucial because although you've achieved much since the Royal Commission was established on the 8th of July 2021, including providing an interim report on the 11th of August last year, much work remains to be done to complete a final report with recommendations that can deliver meaningful change to veterans and their families. Most of the notices that have been issued this year have been directed to the Commonwealth. That is unsurprising given the Commission's terms of reference. And as it has told you on numerous occasions, the Commonwealth is committed to assisting the Commission with its important work. The Commonwealth is well placed to provide that assistance, given, amongst other matters, that Defence has established a task force whose function is to support the work of the Royal Commission, including by the provision of data and information in response to notices. Commissioners, it is essential that the Commonwealth honour its commitment with a timely compliance with notices and other cooperation with the Royal Commission. It is also important that the Commonwealth provide complete responses to the compulsory notices. That is because late or incomplete responses impact the work of the Royal Commission in several respects, including its ability to prepare for public hearings, and of course, alongside those public hearings, the enormous amount of work that is going on to produce the final report. Commissioners, you may recall that at hearing block 8 in Wagga Wagga in December of 2022, late responses to notices from the Commonwealth was a matter that was raised before you. We are happy to say that it appears that the Commonwealth has heeded the call for the timely provision of information. In the time since that hearing in Wagga Wagga, more than 140 compulsory notices have been issued to Commonwealth agencies or witnesses. Commissioners should be aware that the majority of those notices, which have fallen for a turn, have been responded to on time. Of the notices issued in final to the Commonwealth, only one notice was returned late in its entirety. That said, on approximately 17 other occasions, the Commonwealth has returned its response in tranches, with some of those tranches being provided late. It is our hope and our expectation that this cooperation with a timely delivery of responses to notices continues. In particular, can I draw to your attention, Commissioners, that between now and the start of hearing block 9, there are approximately 20 compulsory notices which are returnable from the Commonwealth. Now, that workload is significant, noting the need for parties to be preparing for the hearing block alongside the return of notices to give or produce evidence. But we reiterate that the Commonwealth's timely response to all notices is imperative, and if there are any barriers to ensuring those outstanding notices are returned on time, we ask that the Commonwealth raise those matters before you today. Now, it's important for me to be explicit that while I've addressed you on the timeliness of responses from the Commonwealth, I have expressly not made any comments about the adequacy or scope of the responses that have been provided. If there are issues with the adequacy of the responses, those instructing the Commission will liaise with the Commonwealth about that. And if it becomes necessary, that is a matter that we can raise with you during hearing block 9. Commissioners, if I can then turn to the particular subject matter of the directions hearing today, and that is matters that are impacting our capacity to prepare for hearing block 9, which will commence in Perth on the 16th of May. Now, there are 4 matters that I wish to raise with you. 3 of those matters it will be appropriate to deal with in the open part of the directions hearing. The 4th is a matter that will be necessary to deal with in the closed hearing. We're in your hands, Commissioners, about the approach to take to raising these issues and having a response from Mr. Fordham for the Commonwealth. But it may be convenient for me to deal with each of the matters in turn and then give Mr. Fordham an opportunity to respond.
Are you happy with that, Mr. Fordham?
Yes, Commissioner.
Thank you. Yes, Ms. Longbottom.
Thank you, Commissioner Douglas. The first matter concerns the evidence to be given by Rear Admiral Sarah Sharkey, who is the Surgeon General of the Australian Defence Force. On the 17th of March this year, Defence proposed Rear Admiral Sharkey as a witness who was well placed to speak to the creation of what is called the Mental Health and Wellbeing branch within Defence and the placement of it in what is called the Defence People Group. Now, as you will no doubt appreciate from her title, Rear Admiral Sharkey is part of the senior leadership team of the Joint Capabilities Group within Defence and is the most senior officer in Joint Health. Given that, we consider that she is also well placed to give evidence about governance and accountability issues, which are important matters that the Royal Commission is interrogating, as well as matters concerned with mental health and wellbeing. Now, the Commonwealth, having proposed Rear Admiral Sharkey as a witness, now appears to put in issue her capacity to provide a statement in response to aspects of that notice. The notice was first issued in draft on the 13th of April, but we have been told by the Commonwealth that there will be issues in complying with it in a timely manner. To accommodate those concerns, the Royal Commission has sought to extend the date for delivery of the statement from Rear Admiral Sharkey until the 5th of May. That is 15 business days after the service of the draft and 12 business days after service of the final notice. But we do seek confirmation from Mr. Fordham today that Rear Admiral Sharkey will comply with the summons and be able to attend and speak to the entirety of the matters that are covered in the notice that was issued. We would also emphasise the steps taken by the Royal Commission to work collaboratively with the Commonwealth and accommodate the late delivery of her statement. That accommodation on the part of the Royal Commission doesn't come without a cost. That is because it will impact our capacity to prepare for the hearing. The second matter that we wish to raise relates to Robertson Barracks in Darwin. As Commissioners will be aware, the Commission has been engaging with Defence in relation to Robertson Barracks since prior to the public hearings that were held in Darwin in October of 2022. The Commission has subsequently required Defence to produce certain information in relation to Robertson Barracks, including information about complaints about unacceptable behaviour. The Commonwealth gave comments on draft notices setting out the requirement to produce this information on the 20th of March this year. That information was required to be produced by the 14th and 21st of April. On the latter of those return dates, that is, last Friday, Defence advised us that it would not be able to produce the documents required and that it would be expected to take 4 weeks to, and I emphasise this, collate, review and produce the material. The Commonwealth proposed an alternative approach to provide the information that was sought by the Royal Commission. And on the 27th of April, the Office of the Solicitors Assisting wrote to the AGS agreeing to that approach. But Commissioners may be interested to understand from the Commonwealth the specific timeframes involved in each of the aspects raised in that letter, particularly the timeframes involved in not just collating and producing, but also reviewing the documents, and what is involved in that process of review beyond identifying that documents are relevant to the notice to produce. In raising this matter, can I emphasise it's not lost on the Royal Commission the workload on Defence and its representatives. Having said that, notification on the date of production that material could not be produced for 4 weeks, and this happening after Defence had given comments on the draft notices, is unfortunate. Again, it is a matter that will impact on the preparation of those assisting the Commission for sessions proposed to be heard in Hearing Block 9 in Perth, which starts in a little over 2 weeks. And can I say, in respect to that issue of preparation, it's not just the impact on those working for the Royal Commission, but it's also important to the conduct of the hearing blocks themselves and the capacity of you as Commissioners to get the best evidence possible on these pressing issues under your terms of reference. So it's not a matter that we raise lightly. We raise it because we are concerned that you obtain the best evidence necessary to report on the matters under your terms of reference, and that the public is in a position to hear about those matters in a fully informed way. Now, the third matter that I seek to raise concerns the refusal by Defence to provide a specific response to a question raised in a notice to give. The reference of that notice to give is NTG-NWA-001. The refusal to provide that information was on the basis that compliance may, and I quote, undermine support mechanisms for members and increase the stigma around self-reporting of suicidality. Now, before I embark on an overview of the issues in relation to this notice and the reasons for non-compliance, it's important that I emphasise that either the addressee of the notice or the subject of the correspondence isn't read aloud in an open session because of the sensitivity of the information involved, and it may become necessary, Commissioners, to address aspects of this in a closed session that follows. But can I just step you through the correspondence that we consider important for you to review in reaching an understanding about this issue. The first is having regard to the notice, a copy of which you should have. Can I ask you to look at that in that respect to the addressee of the notice and paragraph 26 of the questions that are posed? As I understand it, but correct me if I'm wrong about this, they have been provided to you as well as counsel for the Commonwealth as a separate aid.
I'm just bringing mine up in the hearing book. I don't have a hard copy, but it's a bit slow in coming up.
May I please have the hearing book reference?
I hadn't appreciated that it was in the hearing book, Mr. Fordham. My understanding is that it was provided as a separate aid, but I am happy to ask my instructors to clarify that.
Is this the one at 0.9989 of the hearing book reference ending in 9773?
That is certainly the letter, and it may be sufficient for your purposes, Commissioner Douglas, as well as Mr. Fordham, because it sets out at paragraph 3 of that letter the specific issue, the specific matter, the subject of paragraph 26 to the notice.
Perhaps, Commissioner Douglas, it was sent to you in an email this morning at 8:50 a.m. as an attachment to that email.
I'll have a look, thanks. Right. Yes, thanks very much. There's several attachments, is it?
It's the third one, I believe.
Thanks.
It's the NTG.
Yep, I've got it. Thank you.
The next document I proposed to take you to was that letter. Can I ask you to read particularly paragraph 6 of the letter at .9990 of the bundle, which sets out a summary of concerns in relation to compliance with paragraph 26.
This is the letter of the 27th of April, is it?
No, Commissioner Douglas, it's the letter of 6 April 2023. It's in MFI 2 at stu.0000.0002.9989 and 9990.
Oh, that's what I was looking for, but
Precisely, yes.
so 9989. Hang on, I'll just go back to that. It doesn't seem to be one of the ones emailed to me.
No, it wasn't. That one is contained in the hearing book.
Bear with me for a second.
Of course.
Takes a bit of time to scroll through. Yeah, I'm getting there, but it's just a bit clumsy. Sorry, I might just search within the document.
We're in your hands, Commissioner. There is no need for urgency on our part. If it assists, the bundle is paginated. The document appears.
I appreciate that. I'm almost there. Hang on. I thought I was. Oh, can the pagination at the bottom right-hand corner, can that be searched for?
Yes, it's at page 217 and 218. You can search for that.
I'll just look for. I'm there now. Okay, 217. Paragraph 6, were you saying?
Yes, paragraph 6.
Yes, I have that. Thanks.
I'll just give you an opportunity to read that, Commissioner Douglas.
Okay. Yes, I've read that. Thanks.
Can I then take you, Commissioners, to MFI 4?
Is that one of the ones emailed to me? The letters of the 27th of April?
Yes, it is. It's the
Okay.
letter that has the reference hearing block 9 in the title.
Thanks. And whereabouts there?
If I could start by having you read paragraph 5, which reiterates a series of concerns in relation to compliance with the notice.
Which reiterates many of the issues raised in that previous paragraph 6.
That's so, Commissioner. And can I just pause to note in that respect that, as we've previously said to the Commonwealth, the Royal Commission is sensitive to the concerns that are raised, but it is important to emphasise that the matters set out in those paragraphs, and I stand to be corrected about this, are matters of assertion rather than evidence before you. Can I then take you, Commissioner Douglas and Commissioner Brown, to paragraph 8 of the letter? And emphasise the underlined passage in that paragraph, which, at least on our reading, is in effect a statement that it's a matter for defence rather than the Royal Commission to determine whether or not it will produce information in response to a compulsory notice. But relatedly, in that regard, I do need to take you to paragraph 10, in which there is a statement that defence will provide a justifiable reason for refusing to comply with the notice. That said, there doesn't seem to be any time frame for the provision of that justifiable reason.
Well, perhaps Mr. Fordham can clarify that.
He may be able to, Commissioner. And before I give him that opportunity, can I just say this? While it's not lost on us that these are sensitive issues, they do also go to the heart of your terms of reference. And the position taken by the Commonwealth is concerning, given not only your compulsory powers, but also the importance of that information. And it is illustrative of some issues the Commission has faced in cooperating with Defence around the content of notices. Now, in large part, the cooperation has been of high quality. But it is important to note that where a notice is directed to an individual and they don't hold that knowledge, it's not solely for Defence or its representatives to redirect the Commission to the repository of that information. It may indeed also be relevant to the Commission's work to establish whether or not an individual in a certain office has certain knowledge relating to procedures, initiatives, or the welfare of those under their command. So that's part of the reason why we've raised this as an issue today, Commissioner. They're all the matters about which we wish to address you in the open session.
Right. Mr. Fordham, do you have any submissions about any of those three issues that Ms. Longbottom has raised?
Yes, I do, Commissioner. Dealing with them in turn, to be fair, Rear Admiral Sharkey was put forward on one basis to deal with a particular issue, being the new body that was formed. It was then suggested that she deal with the issues that my friend has raised. That led to, obviously, an expansion of what it was that was required of her. And where people suggest that they want to deal with things like governance and accountability, that brings a slightly more personal input to what is required. But having said that, I'm instructed that she will be in a position to give that evidence at hearing block 9.
Thanks.
In relation to the second issue, it is in relation to timeframes for the provision of data and how it is that the spreadsheet, if I can put it that way, came about. We have stated on numerous occasions and stand by the proposition that we are trying to give you, Commissioners, the best evidence we can in the most usable format. The idea behind that spreadsheet was to give you, Commissioners, and your assisting team a more useful document that you could work with in order to identify things you might want to further explore. And it was that led to that idea being put forward, and as I understand it, correct me if I'm wrong, eventually accepted. Having said that, it is not as simple as simply interrogating a document. In relation to each item, there are multiple documents and they have to be manually extracted one at a time. Where you have in excess of 160 events, at a minimum, you have to open it, you have to look at it, you have to go through multiple updates through the course of the event, and that then have to manually extract particular documents. So really what I'm trying to say is, yes, the documents were not given in the form originally asked for. In my respectful submission, what has been provided ought to be of more use to you and those assisting you. And if I'm wrong about that, I'd like to be told. And finally, yes, the timeframes are problematic. But as with many things dealing with complex systems, it's not as simple as a simple interrogation by pushing of a button. I could go on, but I think I'll leave it at that.
I can understand that, Mr. Fordham, but I thought Ms. Longbottom was focused principally on whether it's possible to explain the likely periods for collation and then review and then production of the documents, and also why was it that only on the final day for production that these difficulties were raised with the prospect of a further 4 weeks of delay?
That I will have to get instructions on. They may appear on the other screen to my left during the course of this hearing. If they do, then I will address it. If not, I will put something in writing.
Thanks. Was that the focus of your concerns on this issue, Ms. Longbottom?
That's precisely the case, Commissioner Douglas. And just in relation to the issue Mr. Fordham raised about the usability of various forms of information, we're at a disadvantage in terms of commenting on that because we haven't seen anything yet.
Okay, right.
To be fair, I think the object is not to burden your instructors with some of the problems that we face in trying to get the information for you, but I can't take it any further.
Thanks.
If I might deal with the last issue, compliance with that request is problematic for two reasons. And the first is that the person to whom the notice is addressed does not have, or the subject of the notice does not have access to those documents because that person is not in a clinical position. The second, and more important, is this. The concern that I have raised on previous occasions, and I think I addressed Commissioner Brown about this on a previous occasion, is a very simple one. Where it is that people are in a position where they think their records are being interrogated by people known to them, and where it is that those records contain, even if de-identified, contain references to people that would be readily identifiable, Defence and the Commonwealth have a real fear that it has the potential to impact the readiness and the willingness and indeed the ability of individuals who need help to come forward and those who are obtaining help to continue to get that help. Now, it is, with respect, a bit trite to suggest there's no evidence about that, because one might ask, how would I get that evidence? But, as Commissioner Brown would know, where it is that people feel compromised in their ability to obtain help, there is a real risk that they will not. And if one service member does not seek the help that is available to them because they fear that they will be compromised, then the objects of this Royal Commission are not being explored in a way that is victim-focused, in a way that is patient-focused. And that is what we're trying to achieve. Nothing more, nothing less. There have been discussions in relation to other similar notices. I think 129 comes to mind, where there has been talk of trying to do this in a less invasive way that doesn't expose people as much, if I can put it that way, to the fear, with some version of either aggregated data. But to be fair, the Royal Commissions, those assisting you, have said to us they need more granularity. We are willing to engage in that process, but what we do not wish to do is A, have someone who doesn't have access to that material go and get it, which may in fact be in breach of their professional obligations, and B, and perhaps more importantly, put the health and welfare of our members at risk in order to comply. It may take work, and as Ms. Longbottom has pointed out, That is work we are prepared to do, and work that we are prepared to engage on and have often attempted to engage on.
Any response to that, Ms. Longbottom?
Yeah, can I say three things in response? Firstly, it's heartening to hear that Mr. Fordham acknowledges that this data is crucial to the work of the Royal Commission. Secondly, it's troubling to hear the submission, which, as Mr. Fordham has noted, has been advanced on a couple of occasions, that this request raises serious concerns, but equally that there is no capacity to give evidence that would satisfy you as commissioners of that. It may be, commissioners, that we are coming to the time where it is necessary to have evidence about these matters. The third, can I just simply note in relation to the question of whether or not the individual can access the information, can I direct you, commissioners, to, in the first hearing bundle, stu.000.002.9989 at .9991, which is page 219 of a hearing bundle, where at subparagraph E, the matters that Mr. Fordham addressed about capacity to respond are outlined.
About the undue invasion of privacy involved.
That's right. And that's related, Commissioner Douglas, to this issue of the allusion to you being provided with a justifiable reason for taking the approach, but an unspecified date for that to occur.
Do you seek any particular direction at this stage, or are you willing to continue negotiation with the Commonwealth about it?
Commissioner, at this stage, we're willing to continue negotiation with the Commonwealth about it, but it may be a matter that we need to raise in HB9.
And where there might need to be evidence about some of these issues, are you prefiguring?
That's so. Yes,
okay.
That is so. So what I propose is that we can discuss this matter further with the Commonwealth after this directions hearing, and if we don't have a satisfactory resolution, we may seek directions for evidence before hearing block 9.
Are you happy with that, Mr. Fordham?
Yes, Commissioner.
And I take it there are no other directions sought in respect of the first and second items you addressed, Ms. Longbottom?
There's just one matter that I wanted to clarify with Mr. Fordham, and that's in relation to Rear Admiral Sharkey. I understood Mr. Fordham to say that she will be available to give evidence in hearing block 9. I just wanted to confirm as well that her statement will be able to be produced by the 5th of May, which is the extended time frame proffered by the Royal Commission.
I will confirm that, but that is my understanding.
Thanks.
Thank you.
If I could try and deal with one issue that was raised earlier, and I apologise for not doing this because it was a matter in which I held instructions. In relation to the timeliness of the presentation of material that my friend was referring to, as I understand it, it was in the course of preparing the responses that it became clear that the alternative approach that we eventually came to was required, and that was on or about 14 April. It was.
Perhaps it would have been good to say that on the 14th of April rather than the 21st.
Well, I think the position was this, that there was an NTG of nearly 50 pages due at the same time, and that was prioritised why it was considered what the most appropriate response would be. So, put it perhaps more accurately, the problem was identified, but not the solution.
Okay. Well, your opponents or OSA and council assisting haven't seen that solution yet, have they?
I believe it's been discussed with them, but I'm not sure the solution has been provided that I can seek instructions on.
Thanks. But you don't need any direction about that at the moment, I gather.
No, Commissioner Douglas, we don't.
Okay. Was that what we need to deal with in the open hearing?
That is so. We'll ask then for the directions hearing to be adjourned for the closed hearing. I'm informed that that may take about 10 minutes to set up the necessary infrastructure.
Okay.
Sorry, just before we do that, could I just seek clarification from Mr. Fordham? The issue was raised about whether there's any barriers anticipated to compliance with the outstanding 20 notices that are due prior to HB9. Do you have any instructions in relation to that?
I do. If you'll just pass me, give me one moment. There are 2 notices. Right, if I can just, I'm just receiving emails at the same time. If you give me one moment, please. Just to clarify one issue that Commissioner Douglas raised, apparently the spreadsheet was accepted yesterday by my learned friends instructing solicitors as being an appropriate solution.
Thanks.
Now, as I understand it, there are 2 notices over which there are claims for public interest immunity and evidence is being sought, so that those 2 notices are not in a position to be finalised at this point, for the obvious reason that there has to be discussion about that. There will be a delay, as I understand it, in the provision of the statement by Secretary Gregg. There is also a notice that is the subject of a requirement for particular handling that means that we need provision of who it is that is likely to access that particular document for reasons that I won't go into in a public hearing. So that's those matters. As to the balance, my understanding is, and I might be corrected by email if I'm wrong, that the balance of the notices are on track, if I can put it that way.
Thank you, Mr. Fordham.
Thanks. Well, we'll adjourn for approximately 10 minutes. Does that require us commissioners to leave the hearing too?
I'm told that you can stay on the line, Commissioners. There'll just be a process of the live stream being ceased.
Okay. Thanks.
Thank you.
All rise. The Royal Commission will now adjourn.